Because if she called you a liar, I'd be saying the same thing to her. You don't come in here saying somebody's lying to you at all. Because if you tell me somebody's lying, you better bring it and you better be able to prove it.
This opening tells you everything about where this hearing is headed, straight into conflict. Judge Simpson immediately sets the tone like a hammer. This courtroom runs on proof, not feelings, not accusations, and definitely not chaos. And notice what he does here. He neutralizes both sides at once. He's not taking the defendant's accusation. He's not siding with the property manager. He's laying out the rule of engagement. If you say someone lied, you'd better be ready to defend that claim with hard evidence. Right out the gate, he's signaling that today's case isn't about emotion, it's about documentation and compliance. And this is where things get interesting. We've got Section 8 recertifications, lost employment, unclear balances, miscommunication between landlord and tenant, and deadlines tied to legal obligations. All the ingredients for a spiraling housing dispute. The defendant claims she's done her part. The paperwork says otherwise. The landlord wants verification. Nothing has been submitted. The judge, he wants clarity, and he's already irritated. Stay locked in, because this case turns into a tug of war over who failed the process, and the consequences hit hard.
This is the one, the defendant is on Section 8.
Yes.
And she's indicated to me that it's going to begin again in February. I asked for some verification of that. I didn't see any verification. My client doesn't have any verification of that. So at this point, she also says she applied to SER, correct?
Right.
But I didn't have proof of that either. So
you did an SER?
Okay, how you doing? This is the issue. Last week, when her and I discussed it, the complex was saying, first of all, I was working. I do have Section 8. I pay a portion of my rent. I have welfare to work. So the manufacturing, I lost my job. They did just a surprise layoff on the 4th. So at that point, I let the office know this will be my last check. I gave them $700, which is my whole check. I told them that I would have to put this in through my Section 8, let them know what was going on. At that point, they said that I owe $400 for security when I first moved in. I've been there almost a year. I felt that I didn't agree with that. Their paperwork was inaccurate. We met last week on Zoom, and then she was saying that she agreed with me that they didn't know exactly what the numbers were. Now, I guess they have that worked out. So now they're saying that I owe, I believe, $1,700.
This portion of the testimony shows the classic breakdown that happens when life circumstances collide with strict housing rules. The defendant is trying to convey, I'm not refusing to pay. I literally lost my income overnight. She's emphasizing her good faith effort by handing over her entire last paycheck. But legally, good faith isn't the same as compliance. Section 8 requires verification. Landlords require updated billing. Courts require proof. And the bill jumping from $400 to $1,700, that's not unusual when security deposits, prorated rent, and Section 8 recalculations are in dispute. What's striking is her frustration. She believes the paperwork errors were not hers, and that the office didn't know the numbers. Yet legally, it doesn't matter who was confused last week. What matters today is what can be proven. Here's the real tension. Is she genuinely caught in bureaucracy, or is she failing to follow required procedures? This is where housing courts get messy. Intentions don't outweigh documentation. Who do you think is struggling more here? The tenant navigating a confusing system, or the landlord trying to recover unpaid rent?
I told her that I just recently got my job. I start the 29th, so I won't get paid until the 9th. I explained I don't know.
It's luck off.
Yes. What's her name, sir?
Luck off.
Okay, to the lawyer that I'm sorry.
No, it's okay.
Yes, ma'am. I explained to this man.
usually spot it a little bit, but it's okay.
Excuse me. I could go into payment arrangements for the 17th. Excuse me. I can make an arrangement on the 6th, on the 9th, and the 16th. Have it paid off. Then she was explaining February rent. I was explaining to her that I do have Section 8, and I do have my SCR and all my paperwork in here. She was just really not trying to hear it, and I didn't want to evolve the situation, so I just had to speak directly to you. So I was trying to explain to her that I've already put in my paperwork with Section 8 saying that I am not working. They have to verify everything, which takes a minute, but the rent will be paid for February. So that just leaves me with what I got going on now. And she said that's not good enough for her. Then I explained to her I did put in an SER, and she said I didn't have proof. I have proof on my phone right here and a tracking number. She said I was supposed to put it in on a certain day. The reason why I didn't go in on that day because they didn't even know how much I owed on our last hearing. So once they were still trying to figure out everything, I just went ahead. SOS told me to just put in an SER just to protect myself. I'm not really trying to get resources because I can try to do this on my own. I was just trying to put a hold on until I got my paychecks going back. And she didn't seem to understand that. So that's why we couldn't come up to a conclusion or agreement. And she wanted me to say that this is where the problem came in. She wanted me to agree to pay the whole amount. And I told her I was not comfortable agreeing because I have a contract with Section 8. So Section 8 has to pay my portion until I get back able to do it myself, which would be next month. And she wasn't understanding that. And that's what left us to where we are. Sorry, if that makes sense.
Is the claim 1731
Yes,
77?
yes.
Thank you.
And I would ask for entry of a judgment at this juncture, Your Honor. I don't believe the paperwork was submitted to the court like Judge Barr indicated had to be. That's plaintiff's position and request.
I would like an adjournment because I submitted it and
Submitted what?
I submitted the SCR and I.
Did you bring it over to the court?
No, because at the time we went to court. I think they said that it had to be due on Wednesday. We didn't even know they were still trying to figure out what was the amount that was owed because last time we were here, you and I both agreed that.
Okay, but how much was supposed to be submitted?
This is where the case shifts into procedural trouble. The defendant insists she filed an SC, State Emergency Relief Request, but didn't know she had to submit the documentation to the court within 5 days. That 5-day rule is critical. It's not optional. And even though she's emphasizing confusion and mixed messages from the housing office, the burden of process compliance falls on her, not the property manager, not SOS. Judge Simpson zeroes in on timing because timing determines everything: eligibility, stays of eviction, and whether relief can even be considered. If an SC is filed after the hearing or without proper submission, the court cannot rely on it when deciding possession or payment arrangements. The other issue? The landlord's right to clarity. Without updated Section 8 verification or proof of pending approvals, they're being asked to trust a promise rather than documented authorization. Courts never operate on trust. They operate on evidence. Viewers, here's the big question. Should tenants be granted leniency when the system is confusing, or does strict procedure protect both sides equally?
Well, not submitted. How much? Let me go back to the SCR. What date did you do your SCR?
I did my SCR Wednesday night, which means it went through Thursday morning.
Wednesday night being the 10th?
Last week.
Should have been the 10th.
I'm sorry.
The 10th of January?
The day after we had court. I just have a tracking number.
You had court on the what?
It was last week, Your Honor. It was on the 12th.
So you had your SCR in before that
No,
date?
I had it the day after court.
Court was on a Friday, Your Honor.
Well, Monday, I'm sorry. The next following day. I did it after.
So you did it on MLK Day?
I believe so, on the internet. I have the track.
Okay, gotcha. So let me ask you this, and Ms. Luckoff, maybe you can clarify this because this has been coming up for me. At the first hearing, when they're told they need to do that, are they telling them that they need to also have the form?
Yes, they're telling them they need to submit the form within 5 days to the court.
That's not what was told to me. They didn't even have they were still trying to figure out my security deposit. And it's,
No. I'm talking about your form that grants a stay.
I didn't know anything about that, and I tried to explain that to her today. They told me to put in an SCR, and that's what I did.
Judge Barr does.
Who told you this?
FOA. Because we didn't even think that we were going to have to go this far.
Yeah, I know SOS told you that. I'm trying to figure out why the forms aren't being filed with the court. Hey, all right. Do you have anything that verifies your February rent is set, ma'am?
from Section 8.
Yes.
I just have the paperwork, the change of packet I put into Section 8. And I have an email from my worker saying that she's working on everything. I didn't know that I had to have something saying
No,
to verify everything. I'm waiting on Section 8. But I've done everything on my part.
and did you, your SER, there's been no determination on that.
Not that I know of, sir. No.
So what's your intent, or how would you get the 1731 paid?
My intent was to make a payment on the 9th and the other payment on the 16th.
All right, you understand the plaintiff's reluctance to do that because they don't have anything saying Section 8 is going to pay your rent for February.
Sir, they're in a contract with Section 8 that states that if I'm not working Section 8, adjust.
I get that, but they need something from Section 8 saying we're going to pay.
That's in my housing contract. When I first moved there, they state that if something happens, Section 8 covers your portion, and they should know that.
No, you're wrong.
Oh, I apologize.
All right. I mean, you're not wrong in terms of the language. You're not hearing or listening to what I'm saying. If you were the landlord, and I've got somebody that's behind 1731, right? And there's been something with your Section 8, fine. They're asking for some verification that Section 8 is going to cover that February period, your February rent. Okay, they don't have that. Follow me?
I do, but the part I don't understand is it's kind of like they already have a contract with Section 8. Like I explained to her, I can't say I can only cover.
I know they have a contract,
Okay.
but the contract is, but listen, the contract is dependent upon what you do.
So my voucher isn't.
No, because listen to me. Let's say you're saying you reported all this stuff to Section 8, but let's say you didn't, right? The landlord's not going to know that. Nothing changes for the landlord on their end in terms of what they're looking at. But let's say then you did submit it to Section 8, but they dropped the ball and they don't do their part. Again, the landlord doesn't know. You see what I'm saying?
This is one of Judge Simpson's clearest teaching moments. The tenant believes Section 8 automatically covers her portion because of her contract. But the judge explains exactly why that assumption fails legally. Section 8 payments are not guaranteed unless the agency has officially processed, verified, and approved the change. From the landlord's perspective, nothing is certain without written confirmation. Judges see countless cases where tenants think they submitted paperwork, but the agency didn't finalize it, or lost it, or delayed it for weeks. Without official proof, the landlord assumes full risk, and no court forces a landlord to rely on uncertain benefits. The real problem? The tenant doesn't understand why the landlord wants verification, and the landlord doesn't trust a verbal assurance. That gap is exactly what leads to eviction judgments. Ask yourself, is the judge being too rigid, or is he protecting the legal process by demanding evidence?
All right. So the issue here becomes how are you, and if you can't get the 1731 paid before February 9th, you got a problem.
I tried to go to a payment arrangement for the 1,700, which I told her I could have it all paid off by the 16th. Going back to work of February, which means I'll just pay on the 9th and the 16th. That'll cover the 1,700. But she wanted me to commit to the other 1,400 for February. That's where our problem came in.
Right. Because they don't, if you listen to me, because they don't know if Section 8 is going to pay it. That's why she wants you to commit to pay it. If particularly she wants you to commit to pay it if Section 8 doesn't.
I have no problem with that. It's just the way she said it. I felt like I was being backed in. How she explained it to me, Your Honor, it was like she was saying I didn't even have Section 8. I was lying. and I was showing her
All right,
email.
I've listened to enough here.
Okay,
I was showing her
ma'am, stop, because that's not true. No, that's not true. Ms. Luckoff has been before this court time and time again, and I'm going to tell you something. She doesn't lie to people. She just tells them the truth. It may not be what they want to hear, but she doesn't lie to people. And no, listen. Because if she called you a liar, I'd be saying the same thing to her. You don't come in here saying somebody's lying to you at all. Because if you tell me somebody's lying, you better bring it and you better be able to prove it.
Okay, sir, she was saying that I was telling her other than the truth, but I was showing her the emails where we were going back and forth about.
That
this.
is absolutely
saying
untrue.
that
I'm not,
I
I
have proof.
said there's no proof.
I'm about done with you.
This is the emotional breaking point. Judge Simpson's patience snaps, not because of the debt or the Section 8 confusion, but because of credibility. Courtrooms run on respect and listening. When a judge feels a litigant isn't absorbing instructions, tension escalates fast. His reaction here is a warning about courtroom conduct. Accusations against attorneys or caseworkers require evidence. The defendant's repeated statements about being told one thing or being called a liar clash with what the judge knows about the officer's reputation. That's why he steps in aggressively. He's protecting the integrity of the process. The tragedy is clear. She's overwhelmed, emotional, and genuinely confused. But emotion doesn't override rules, and it doesn't override the judge's demand for clarity and proof. The more she explains, the more he feels she's contradicting established procedure. Should judges show more patience in moments like this, or is firmness necessary to maintain order?
I'm sorry.
No, I'm about done with you. Because I'm going to tell you what, when I'm sitting here and explaining it to you, you weren't listening to me. So I know exactly what was going on as Ms. Luckoff's talking to you. You're not listening to a darn thing she's telling you. And you're just making up whatever you want to make up to try to figure it out. And then I'm going to sit up here and try to call her a liar. That doesn't work here. No, there's no apology necessary. And I don't accept it. Because even after I told you she didn't lie to you, you said it again.
I don't know how else to prove that what I'm saying besides trying
The
to.
money's owed. I'm going to find no tribal issue. I'm granting judgment to the plaintiff for possession. Judgment amount $1,731.77. Writ to issue 10 days. Come up in here and act respectful to people, then I don't have a problem with you. But you don't do it, I'm done. Bye. Have a good evening.
So just can I appeal this or what?
You can appeal it. Paperwork's down the hallway. Court calls the case of Arbor One West versus Mercedes Houston.
Your Honor, the parties
Hello,
have,
what's your name?
Mercedes Houston.
You got something to say about Ms. Luckoff? No. Go ahead. No, go ahead.
This ending is blunt and unforgiving. Judge Simpson rules there is no triable issue, meaning there is no dispute requiring further litigation. Without verification from Section 8, without timely SC documentation submitted to the court, and with significant arrears outstanding, the legal outcome becomes inevitable. Possession is granted to the landlord. The tenant is advised she can appeal, but appeals rarely overturn cases grounded in missing paperwork and procedural noncompliance. This case is a powerful example of how quickly housing disputes escalate when documentation, timing, and communication break down. The tenant genuinely tried to navigate job loss, Section 8, and emergency relief, but effort alone doesn't satisfy legal standards. The landlord needed proof, the court needed compliance, the system needed verification, and none of it materialized in time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.